Right. I declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee for the Migration Amendment 2026, Measures Number 1 Bill 2026. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers to be given evidence in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear. And witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. I now welcome representatives from the Department of Home Affairs. I thank you for taking time to speak with the committee this afternoon / this evening, getting into this evening. For the Hansard record, would you please state your full name and the capacity in which you appear? I might just say, do you have an opening statement that you want to make, and then as you're going to respond to questions in the usual process that we do things, to state your name and the capacity in which you appear.
Thank you, Senator. We don't have an opening statement, but for the Hansard, my name is Claire Sharp. I'm the Head of Immigration.
Excellent. Thank you, Ms Sharp. In that instance, we'll proceed directly to questions, and we'll start with Senator Delija.
Thank you very much, Chair. Thanks for coming along for the briefing today, or for the hearing. Can you please explain to the committee what the bill will do?
Certainly, Senator. The bill is directed at ensuring that the Australian government has the ability to respond to sudden changes in the international environment. It provides the government with the power to suspend travel for certain non-citizens, allowing adequate time to better assess and manage risks associated with those non-citizens travelling to Australia, and really is intended to respond to for an event overseas. In some ways, it's really about us being able to manage the border during a large-scale event where we quite simply could not respond on a case-by-case basis. The bill gives the government the power to issue an arrival control determination that suspends the travel of a specified class of temporary visa holders for a period of time that can be up to 6 months. It then provides for a range of safeguards, which we can take you through, and also provides for a process whereby individuals who need to travel to Australia can seek a permission through a certification process. The mechanism is designed to ensure that we can have control of who is entering, and ensuring that those who were granted a visa before the crisis on the basis at the time, and when they were granted the visa, they did satisfy us, they were a genuinely temporary entrant, don't enter Australia if we were to assess their visa application now, may well conclude they are not coming for a genuinely temporary purpose.
Thank you for that. And will the bill or the amendment suspend travel for all individuals that are currently hold any visa to Australia?
So was that, will it...
will the bill, will it suspend travel for all individuals that currently hold any visa to Australia?
No. It's much more limited than that. The bill itself gives a power to make an arrival control determination, So the bill doesn't suspend travel. The next step is the minister, with the agreement of the Prime Minister and the Foreign Minister, have to make an instrument where they actually specify which non-citizens it would apply to, but the framework sets up rules and safeguards around who it can apply to, and it can only apply to temporary visa holders, and it cannot apply to temporary visa holders where the temporary visa is a humanitarian visa or where the visa holder is the spouse or de facto partner, child or parent of a child who is an Australian citizen or permanent resident. That's really designed to ensure that close family members of Australians are not affected.
Great. Thank you. And will the bill establish a personal power of the minister, and what are the powers?
I might start, and my legal colleagues may assist if I misunderstand the legal meaning of personal power. The power will be vested. The person who will make the determination is the Minister for Home Affairs, but he can only make it if he has the agreement of the Prime Minister and the Foreign Minister. It's not, the power to make the determination is not one that will be delegated to officials.
Kevin Cunnington, Assistant Secretary Legislation. The legislation also makes abundantly clear that it cannot be delegated as expressly provided in the law as a personal power of the Minister.
All right, excellent. And is there not an existing power that can be used?
No. Well, not to do this by a group of non-citizens. At the moment, each visa holder who's coming into Australia on a temporary visa must satisfy us that they are coming for a genuinely temporary purpose. That's a visa criterion, and that's assessed at the time the visa is granted. We do have the ability to review that but when they're offshore, and on an individual basis, if we come to the view that the visa condition is not going to be satisfied, we could cancel the visa. However, we would need to do that currently on the current law, case by case, one by one, and it's very resource intensive. It's not possible for us to do that in a practical sense for a large group of people at the same time.
Excellent. And with the arrival control determination, what will it actually do, and what's the expiry date?
The effect of an arrival control determination is that for the group of people who are specified in the determination, they cannot travel to Australia. They don't have a right of entry into Australia for the duration of the determination. The determination is for the period that is specified in it, but it is a maximum of 6 months, so up to 6 months.
And what will happen if an extension would be required?
It cannot be extended. If at the end of the 6 month period, the Minister considers that there continues to be an international event that warrants an arrival control determination, he needs to go back through the process and make a new one, get a new agreement from the Prime Minister and the Foreign Minister, and again work through the tests that's provided for in the legislation about the national interest and forming the view as set out in section 84B2, meeting that test.
Thank you for that. And just confirming, the minister will the minister be the only one with the power to make that determination?
Yes, the legislation specifies that the determination is made by the Minister for Home Affairs with the agreement of the Prime Minister and the Foreign Minister.
And can you just tell me about individuals who are onshore who have a temporary visa prior to establishing the arrival control determination? So what will happen in relation to those individuals?
An arrival control determination only affects temporary visa holders who are offshore. It does not apply to people who are onshore.
Yeah. And what would happen if there were people with certain circumstances, for example, compassionate, who looked to be able to enter Australia?
The legislation provides for the power to issue just get the technical name, a permitted travel certificate. In practice, we expect there will be a number of these that will be needed, so that power to issue a certificate that would then permit that particular person to travel to Australia on their visa That power will be delegated to the department, and we will put in place a system where people can apply for travel. We will assess whether we consider there is a reason for the travel and that it's necessary, and then if so, we can grant the certificate.
And is the determination able to refuse or cancel visas?
No, the determination doesn't cancel the visa. If the visa, it might be easier if I use an example. If the visa was specified to run for 12 months and the arrival control determination was made for the first 6 months of the life of that visa, at the end of the 6 months, that visa will come back into effect and is available for use for the remaining 6 months of the life of that visa.
All right, thank you.
Thank you, Senator Delija. Senator Dunniam.
Thank you, Chair. Thank you for coming along at short notice. When did you start working on this bill?
I might get Mr Cunnington, in terms of working on the, drafting instructions were issued on Thursday last week? Friday last week.
Okay. And when was it identified that this gap existed in the legislation that needed this remedy?
Senator, in response to the kind of crisis in the Middle East, we turned our minds to the number of, as you would expect, the number of visa holders in the region, alongside our colleagues in the Department of Foreign Affairs who were thinking about the number of Australian citizens overseas as well.
Yes.
And in that context, we were thinking about what our system would do in response, and we also looked at the number of people or from countries who are affected by the crisis onshore, and in that context, as we worked through what our system could cope with and pressures on it, we identified that we could not stop a whole class of people moving at the same time, and that an additional power would be needed to be able to do that if that's what became needed as the events unfold.
Sure. Has there been any application of the existing laws which enable the individual cases to be dealt with on a case-by-case basis? Has there been any of that underway since the crisis in the Middle East?
Not at this point in time. With travel practically with travel so restricted right now, it's not a large-scale problem. What we anticipate is as flights start to be able to move, that's when the power is more likely to be needed. And so at this point in time, no, we haven't needed to the best of my knowledge, at scale to cancel individual visas. We constantly monitor visas, but we haven't had an active kind of search for those who aren't genuinely temporary at this point in time.
Yes, so individuals that might be in this cohort of scale haven't been individually processed to have any sort of temporary or other revocation.
We don't have a power to temporarily revoke.
Right.
We would need to cancel the visa, and we would need to meet.
It.
Yes,
yeah.
That's right.
Okay. If I can just go to some of the specifics in the legislation then. Under this new, I think it is section 84B around the arrival control determinations, I just wanted to go to the definition of event or circumstance. How is that defined?
It takes its ordinary meaning.
We've been here before, haven't we? So what is the ordinary meaning of event or circumstance, and what threshold is applied? I think
it's better to understand it in the context of that subparagraph A, and it's conditioned by subparagraph B and C, because an event or circumstance, as you know, in the ordinary meaning, can be something big or small, which is why you need to read paragraph B, which talks about the effect of the event or circumstance on that visa. So subparagraph B is that because of the event or circumstance, the effect of it is that if the non-citizen were to enter Australia, they may not
Leave.
They may not leave. Or the other paragraph is because of the event or circumstance. If that had been in play at the time the visa was assessed, they wouldn't have been granted the visa.
Yes.
So I think that's the only way to understand what kind of event or circumstance we're talking about here. It has to be large scale and the change needs to be relevant to the visa criterion. And in this case, we're focusing fairly heavily on that genuinely temporary entrant criteria particularly.
Is there anywhere else in the Migration Act that we refer to event or circumstance as a factor for considering actions like this or any other suspension or revocation of a visa?
I would have to take that on notice unless...
In relation to cancellation powers, which Ms Sharp has mentioned operate only in respect of an individual, there are grounds in, for example, section 116 that refer to the circumstances applicable to grant of the visa. But as Ms Sharp noted, that is a thing that you would exercise only in respect of an individual. I would also, if I may, just note, in addition to what Ms Sharp was stating, that the objects provision, so section 84A,
yes,
actually does frame, for the purposes of understanding the nature of an event or circumstance in the context of these provisions,
yes,
the kinds of risks or matters that we are actually directed to, and that the Minister is in fact required to consider. If you take yourself to paragraph C, where the Minister is, in fact, by the legislation, directed to have regard to the object of the subdivision when considering whether it's in the national interest to make the determination. And that object directs the event or circumstance outside Australia where there would be, or it means there is, an increased risk that certain classes of temporary visa holders will not depart Australia when their visa ceases to be in effect.
And so the determination that an event or a circumstance has occurred or is occurring is made by who? The Minister or the Department?
The determination is a legislative power of the Minister.
Yes, the determination to revoke or suspend the visas of a class, yes, but who? So the Minister receives advice from the Department, I presume. The Department will have determined an event or a circumstance is occurring, is that right?
Or the Minister has to determine that.
The test is, if you look at subparagraph 84B2,
yes,
it's the Minister must be reasonably satisfied. So
the Department makes a case that...
Yeah, in the ordinary course, we would write a ministerial submission and the Minister would consider that, but it is very much the Minister's decision, not the Department's.
No, indeed, yes, as stated in answer to the previous block of questions. Okay, so it's ordinary, meaning there is no hard and fast threshold. It is in the context of those elements that you outlined there in 2A, B and C, or B in particular. When we come to... Where was it?
Could I ask a quick follow-up?
Please, yeah.
Just on the event or circumstance, so therefore it doesn't actually have to be a discrete identifiable circumstance. It could be a gradual deterioration in conditions in a country.
Yes, circumstances would cover, I think, a situation you're describing, as long as you need that link to the visa. The nexus to something relevant to the visa. It's about that there is an increased risk that the person will not leave, and by increased, we're measuring it against when we granted the visa. So, yes, I think it is possible that a deterioration in conditions could meet the test, but we would need to be able to make out the link to the visa criterion.
Thank you. I'm going to use that opportunity with the interruption of Senator Cash to share the call, and I'll come back to you. Senator Shoebridge.
Oh, thanks very much, Chair. And thanks to all the officials for coming at such short notice. If this bill was in place and a determination had been made in relation to Iran, then because of the class of visas they were on, the Iranian women's football team would have had their visas suspended. Is that right?
Senator, that would depend on the determination that had been made, as the minister may make a determination by specifying particular groups of non-citizens, and so if that visa class had been named, then if the visa class those women are travelling on had been named, then that is possible. Then yes, it would apply. But it
doesn't require a visa class. It requires a class of persons, doesn't it?
Yes, but we need practically a way of identifying who they are.
If the class of persons were, and I'm sorry, I know it was my understanding that the way in which it's envisaged classes of persons will largely be determined is due to their travel document. That's then the nationality, or the travel document that identifies the nationality they're travelling on, as well as the type of visa, are the two points that for our systems it's easiest to identify a group or a class of people. Yeah, and the bill excludes certain types of visa applications in 84C4. And obviously none of the Iranian, well, it would only be by happenstance that any of the Iranian football team were de facto partners or children. So that exclusion on the face of it wouldn't apply, correct?
Without commenting on individual cases, I don't want to comment on those people's marriage status, but...
well, unless they've been married to an Australian citizen, they were the parent of a child under 18 who's an Australian citizen, or married to the holder of a permanent, unless they admit, on the face of it, the Iranian soccer team aren't here on the basis of meeting those criteria, on the face of it.
Yeah, on the face, yeah.
And of course, at the time the visas had been granted to the Iranian soccer team to come, to the Iranian football team to come here and play soccer, the relevant circumstance has been the war in the Middle East. That wasn't in play at the time that the visas were granted. And so, as I understand the government's intent, the intent is to ensure an arrangement like that, where visas have been granted to football players, women's football players turn up in Australia, circumstances change, and now some of them apply for asylum and protection visas. That's the very circumstances you're trying to prevent happening in the future. People come in here under one visa, and then once they're here under that visa, circumstances having changed, they apply for asylum. It's a case study in what you're trying to prevent happening, isn't it? The protection that's been given to the 5 Iranian women.
Senator, the law doesn't apply to visa holders who are onshore in Australia, recognising that at the time of a crisis erupts, Australia does want to support and those people. It does recognise, however, that there's a very large number of temporary visa holders offshore, and it is trying to manage the impact on Australia's migration system should they all choose to travel at Australia immediately after the event.
So this has been put as a matter of urgency because of international circumstances. This all seems to be some kind of strange code for the conflict in the Middle East, the war in the Middle East. That's what's driving the urgency of this, is that right?
Yes, I think I just gave evidence to that effect.
And in terms of visa numbers for the countries in the Middle East, there's about 7,200 temporary visas that have been granted to people with Iranian travel documents, is that right?
The figure's about 7,200 visitor visas.
Yep. And is that the number of visas that, on the face of it, this bill could apply to if a determination was made to apply to people with Iranian travel documents, 7,200?
So, sorry, Michael Willard, Deputy Secretary, Immigration Programs Group. It would depend on which what the class of persons was defined as to whether it was...
That's the potential scope, 7,200 visa holders, temporary visa holders from Iran.
That's visitor visa holders.
Yep. And do you have the numbers for other countries in the Middle East where the instability, the violence, the bombing, the killing is maybe suggesting people may not want to go back after they return to Australia?
I have a figure for the Middle East. I'm not sure I can define every country in the terms you just put it, but this is a geographic figure. It's not a figure based on what's happening in particular countries. The figure across the Middle East in terms of temporary visas held is 61,000.
61,000, and the 7,200 is a subset of that?
That's a subset, so that's Iranian visitor visa holders.
How many from Lebanon?
So for Lebanon, the figures are 1,150.
Okay. And how many?
Again, that's all temporary visas held by holders of Lebanese travel documents who are offshore.
Yeah, Mr. Willard, my understanding is the answers you're giving me are to that effect. If I ask you about a country, you're talking about temporary visas from people who hold a travel document granted by that country and who are offshore. Palestine?
So Palestine, the figure is 157.
Do you have Syria?
I do. Syria, the figure's 207.
207. Do you have the Gulf states?
I have them separately, yes.
Mr. Willard, so perhaps rather than me work through my geographical memory of the Gulf states, can you give them biggest to smallest if you've got it, or just in whatever order they're there?
I've got Bahrain at 503. I've got them by country, Senator, so I'll have to work through them that way. Kuwait is 2,584. Oman is 1,067. Qatar is 1,096. The UAE is 6,435. I think that covers the Gulf states.
Do you have Israel?
I do have Israel. Israel is 11,070.
And the last country I'd ask, last two countries are Saudi Arabia and Iraq.
So Saudi Arabia is 9,801. And Iraq is 558.
558. 558. Which of these countries, who would have all been impacted by the war, many people of which will feel unsafe and insecure and may wish to come to Australia and then put an asylum claim in, which of these countries is the government intending to target with this legislation?
Senator, based on the current state of events, nationals from Iran are, I guess I'll put it this way, nationals from Iran are the most impacted by the current events, and at this point in time it would be challenging for somebody applying for a temporary visa to meet the genuine temporary entrant test, and so that would be the group who, based on the current circumstances, are most likely.
Thank you, Senator Shoebridge. I'm going to rotate the call and come back to you. Senator Thorpe.
How will you determine the specified cohort of people And no, wait, let me go back. You suggest people shouldn't be on a temporary visa if they genuinely need to claim asylum. So how can people claim asylum if the UNHCR waiting list is literally years?
Senator, that's a real problem. There is a very large number of people seeking asylum worldwide, and many more than Australia has places for. The process when someone is offshore to claim asylum is often done through the UNHCR, but people can also make an application directly to us on our website.
I only have two questions. How do you determine the risk of someone remaining in this country? Because everyone here, except for two, aren't even from here. So I'd like to see everyone else's visas pop up. And I'd like to decide who comes and goes. But so how do you determine the risk if someone remaining in this country after their temporary visa expires? Is it based on skin colour or religion? Is it about Muslims? Because this is what it's looking like, right? This is like, you don't want any more Muslims in this country. And so we're putting together some ledge to make sure that happens, because that's what Trump does. That's what he's done. So is this what you're doing, and how do you determine the risk? Like, what is the risk? Because they're black?
No, Senator. We have a set of... We have a very data-informed approach where we look at the characteristics of people who do overstay or break their visa conditions, and we use that information to inform the level of scrutiny that we apply to applicants with similar characteristics. That is not based on religion or skin colour, for abundant clarity. It is based on things like if we see a group, for example, a scam operating in a particular area where people are consistently claiming that they're coming to study a particular course at a particular institution, and then they don't do that. We feed that back into our system to inform the way we approach visa applicants who claim the same thing. Mr Willard might want to add more detail to that.
There's a huge number of data points that get fed back into the system. What that does is help inform a decision maker to apply all of that information in the context of an individual and their circumstances. So ultimately it's a consideration of that individual and their circumstances, but it's informed by all of that data in terms of information around what's happened in the past in respect of visa outcomes, and also what sort of indicators we get in terms of common involvement in visas or other information that helps us identify risk.
I'm done.
Thank you, Senator. Senator Dunning.
Back to a few more process questions, and then probably following on from some of the questions that Senator Shoebridge had. In 84B, subsection 3, it talks about the Minister needing to obtain agreement in writing from the Prime Minister or Minister, the Foreign Minister, I presume, who administers the Diplomatic Privileges and Immunities Act. What's the exchange of information to obtain that agreement? Is it the advice that the Minister has received then passed on to these other ministers, or how does it work?
I might start and then pass to my legal colleagues. The legislation on its face doesn't specify the kind of factors that the Prime Minister or the Foreign Minister need to consider.
Yes.
The legislation goes to what the Minister in 84B2 needs to have regard to.
Mm-hmm.
I think it would be a matter for... I would expect, based on ordinary practice, generally this sort of thing would be done by way of an exchange of letters, mm-hmm. where the Minister would set out what he's considering and seek their views.
And Senator Brooke Hartigan, Deputy Secretary Legal. On page 10 of the bill at 84F, If the minister is to make a determination, he or she must prepare a statement of reasons for making the determination. So you imagine that would be something that would be being pulled together for the purposes of consultation with the ministers as well.
Okay, all right. On the length of these determinations, how do we determine, so it's up to 6 months, no more than 6 months. If the minister decides to do 1 month or 2 months or 2.5, whatever it might be, how is the length determined?
I think that would be having regard to the factors in 84B2 around, you can see there's a national interest test as well as the nature of the event itself. So, there's a very strong national interest in us having a free flow of temporary visitors and the like to the, and an economic impact if you were not targeted in this kind of determination. And so in thinking about how long to apply it for, the minister, with the agreement of the Prime Minister and Foreign Minister, would be weighing up the relative impacts on Australia of having it in place against the importance of protecting the integrity of our visa system.
Okay. Just in terms of, again, under section 84B, under subsection 10, it talks about nothing in this Act prevents the Minister from exercising the power in subsection 1 more than once in relation to the same event or circumstance or the same class of non-citizens. Can I just understand what the effect of that is? What is it enabling the Minister to do that, if that section wasn't there, would otherwise be prohibited?
That provision in some ways, and Mr Cunnington might correct my language here, but in some ways isn't for the avoidance of doubt provision. Right. What it is doing is making clear that at the end of the 6-month period, when a determination is made, if the same trigger event is still ongoing, a new determination can be made in relation to that event.
To extend, in effect.
To make a new one.
Yes.
But the important point is that the Minister has to work through the tests set out in 84B. Again. He can't just rely on his reasoning and statement of reasons from the first one.
Yes.
A new agreement.
Fresh assessment. And
that's right. New application of the national interest test.
Okay. All right. And just in terms of the migration zone, as referenced in the Act, does that refer to Australia? Is that what is a migration zone, just so I can understand? Because, and my 84C...
There's a layman's answer and a technical answer.
Let's go to layman's.
The layman's answer is Australia.
Okay.
My colleagues could give you the precise answer if you'd like it.
That's basically just saying that they have to be offshore in order...
That's correct.
Yeah. Okay. I just want to go back to some numbers. In answer to questions from Senator Shoebridge, you went through a range of numbers of, I think, was the category temporary visa holders. Is that how you classify them? Yeah. You said for Palestine it was 157. And at estimates, I just want to understand the difference between the number we got at estimates, which for the same jurisdiction for 23-24 and 24-25 was 6,957 visa decisions. Now, can I understand what the 6,957 minus the, I guess I know it's a different period of time, but 157 would be? What other categories are we talking about there, and would any of that number in any way be impacted by this legislation?
So the figure we're talking about here is temporary visas in effect to people who hold Palestinian travel documents who are offshore. The cohort is any of the temporary visas that could be, subject to how the determination is made in terms of a class of persons, could be affected by this decision. The figure that I've given in estimates is the number of grants over a period of time. Typically it's since the end of 2023, yes. And so it's an accumulation of visas over that time, some of which have been used, some of which, or all of which, many of which would have ceased by now, so are no longer in effect, some of which would be visas that people use to travel to Australia, so they're onshore.
Yes.
And
So
out
they're
here.
excluded.
So it's a stock and flow difference
I understand
between
what you're
the two numbers.
And would the exclusions and exceptions outlined in the bill also account for some of the difference in numbers between 157 and 6,957?
I think most of the, and I don't have the 6,900 breakdown, I think most of those were visitor visas, which means they're no longer in effect offshore.
Sorry, I just missed, I couldn't quite hear.
Which means those visas are no longer in effect offshore. So this is the visas that are currently in effect offshore.
Right. The 157 are currently the ones.
Yeah, 157 is the current number of temporary visas in effect offshore.
Okay. Okay.
Just one further point that's important to note about all of this data. It's linked to the travel document the person holds.
Yes.
It does not necessarily mean the person is living. They may have a right of residence in another country.
Mm-hmm.
So just in thinking about, you could be a Palestinian travelling on a Palestinian travel document, but have a right of residence in another country.
And would that exclude you from the application of this determination?
No, but that's where the permission certificate might well be quite important.
To override.
That's right, because we can't do that granular assessment for every case.
Yes.
What this does is put a general rule in place, but we're then with the ability of someone to say, I am a genuinely temporary entrant. I have a long-term right of residence in this country that is unaffected by the crisis. I'm definitely going back. My business, my family are all there. And that would be a classic case where there'd be no risk to Australia in continuing the travel.
Sure. And just before I have to hand back the call, you did step out for Senator Shoebridge that the circumstances in Iran are what is in mind when these laws were drafted. I mean, are there other examples over the course of time where such provisions or a bill rather of this nature would have been useful? I mean, I specifically think about the Israel-Gaza conflict. I mean, is that the kind of thing that, or the numbers just weren't significant enough to warrant?
Certainly a feature of this current crisis. It's very volatile, it's involving a lot more countries, and the situation is changing rapidly. That is one of the reasons why we advised the government that we thought a power like this would be in Australia's interest, because it's a larger area and Iran itself is much bigger, larger number of visa holders. It's a bit hard to sort of look back over the annals of history. But the other point I would note is we have more temporary visa holders, like people holding Australian temporary visas now than we've ever had before. That's a feature of just a global economy and a lot of movement of people.
Sure.
Just two very brief follow-ups. The event or circumstances outside Australia trigger is quite vague. Does that create legal uncertainty and leave it open to challenge? And would it be better to define specific categories of triggering events that automatically satisfy the threshold? That's the first question. And just secondly, I think it's just a point of clarification. The bill only suspends existing visa holders from travelling. Is that correct? Does it do anything to prevent new visa applications being lodged and granted to people from the affected country?
I might answer the second question first. It does not bar new applications. In practice, what we would do is make it very clear on our website when someone is looking to apply for a visa that the determination is in place, because we don't want to mislead people about the effect of the application. But we would continue to receive applications and assess those, recognising this is a temporary measure. It's not intended to be in place forever, and so that's why there is no bar on applications. Your
legal challenge in relation to the definition of event or circumstance outside of Australia?
I think we've been quite deliberate in what Ms Sharp said before, event or circumstance, because what we're seeing in the Middle East is evolving on a sort of daily basis. it is caveated by what's following after event or circumstance, so in 2B and 2C. So you still have to meet those other criteria, and then finally for it to be in the national interest. We felt that that sort of provided some safeguards around event or circumstance.
Thank you, Senator Cash. Senator Shoebridge.
To be clear, the intent of this bill, as I understand it, is to say that there's 7,200 people who have been assessed as fit to get a visa to Australia. They might be prospective spouses, they might be tourists, they might be business. They've been accepted as fit to get a visa for Australia, but now the war's been launched against Iran. Australia supports that war. It's now incredibly unsafe for them to go back to Iran. The government wants a power to freeze those visas because the fear is they'll come to Australia on those visas, and because of the war we support, they won't want to go back to Iran and they'll want to seek asylum. That's the nub of it, isn't it?
I think the easiest way of answering that is the object of the bill is set out in section 84A, which is that where it's necessary to protect the integrity and sustainability of our immigration system, including when there is an event or circumstance outside of Australia that means there is an increased risk that certain classes of temporary visa holders will not depart Australia when their visa ceases to be in effect.
You see, when Israel's assault on Gaza commenced, well, the most recent assault on Gaza commenced, the government took a very different approach, realising that it's next to impossible to get a refugee asylum claim up in those circumstances from a country while it's been attacked and under war. The government decided to permit tourism visas, short-term tourism visas, to be given so that if Palestinians could escape the conflict, they could arrive on shore and make an asylum claim. Now, that's only 2.5 years ago that happened. It was decided that a tourism visa would be a perfectly positive and useful vehicle to allow this exact thing to happen. Has the government now looked at that and said, well, we don't want to give that opportunity to people fleeing the conflict in Iran? It seems to be what's happened. You don't want to give and by that I mean the government, doesn't want to give that same opportunity to people fleeing the conflict in Iran.
Senator, the bill very deliberately excludes all humanitarian visas from its effect. We strongly prefer that where a person is coming to Australia for a purpose, they obtain the visa that reflects their circumstances. So Australia maintains a generous, very generous by global standards, humanitarian intake, and we want people who are going to avail themselves of that to come through that intake so that we can apply the priorities to that intake.
We don't have a lot of time this afternoon, and so if you could address the question I put to you, which was barely 2.5 years ago, the Australian government said to the people who could flee the killing in Gaza, the Palestinians, you can apply for a tourism visa that'll get you here, and then once on shore, you can apply for a humanitarian visa. The exact same government is now saying to the people of Iran, we're not going to give you that opportunity. Even if you have an existing tourism visa, even if you have an existing visa, we're not going to give you that same opportunity. Has there been a policy change? Has the government looked at what happened in Palestine and said, no, actually, we don't want to give people that opportunity? That seems to be what's happened.
Senator, the change is the government is putting forward this legislation and very clearly articulating that we want to support humanitarian entrance to Australia. We have a generous humanitarian program and we want people who need to avail themselves of that to come through the humanitarian program.
Has Home Affairs been working with and consulting with the Foreign Affairs Department and the Prime Minister's Department, because both of those departments have been saying they're concerned about Iran, the people of Iran. They want to protect the people of Iran. Have they had any input into this? Because this bill does the exact opposite. This is there's 7,200 people of Iran who we will not be offering that opportunity to. As Home Affairs and Prime Minister's Cabinet, has their public rhetoric, their position about protecting people from Iran, have they been consulted?
Senator, we've followed ordinary government processes in the development of this bill.
Has Foreign Affairs and PM&C been...
Yes, they have.
Why was the decision taken to not make these instruments disallowable, to prevent the Senate having any oversight of what might be an incredibly far-reaching power?
The legislative instrument that is to be made by the Minister is not disallowable, noting that it provides certainty in terms of when the period commences and when the period ends. There is a tabling requirement and a statement of reasons, as Ms Hardigan also noted, that must be tabled within 2 sitting days.
Sorry, Mr Cunnington,
after the
I know
determination
it's
is made.
not disallowable. I'm asking that was implicit in my question, my knowledge that it was not disallowable. I'm asking you why it isn't disallowable.
To provide certainty in respect of the period and therefore the effect within that period on those temporary visas that are covered as a result of the determination.
But a disallowance only operates prospectively, so it would still provide certainty. It would just give democratic oversight. So was there a conscious decision not to give the Senate that power?
Senator, this power has been designed for use in urgent or emergency situations, and for that reason, as Mr Cunnington said, it's designed to be used quickly, and for that reason we wanted certainty about what its effect was. It only applies for a maximum period of 6 months, and so they were the safeguards built in rather than a disallowance period.
But the terms that's used to grant it, circumstances, are so broad that even if an overall event was continuing, a war, a natural disaster, even if that was continuing to have effect, circumstances inevitably change over the course of 6 months. You could issue a fresh determination in relation to the same class of people relying upon a change of circumstance, couldn't you?
Yeah, as we've outlined before, the key limit on what kind of event or circumstance is it has to be relevant to the visa and the likelihood that the person is at an increased, or the group of people, I should say, are at an increased risk of not leaving.
To be clear, one of the circumstances that this could apply to would be a natural disaster. So if one of our Pacific neighbours suffered a tsunami, or there was a terrible volcanic eruption, this could be used to prevent people from one of our Pacific neighbours who had visas coming to Australia because they may not want to return to their country which has been devastated by a tsunami. Could be used in those circumstances, couldn't it?
Senator, I guess what I would say in response, and noting that's a hypothetical, is the overarching intent is to ensure that we can protect our humanitarian program, and for those who need Australia's humanitarian support, that we can prioritise the places we have for those most vulnerable and in need.
This is about excluding people, preventing people, where world events is creating a potentially desperate need for protection, whether it's a natural disaster, whether it's a war. This is designed to exclude people who need urgent protection because of what's happening in the world. That's at the core of this bill, isn't it? When bad things happen, we want to be able to say no. That's what this bill does.
Senator, I don't think I can add anything further to my previous answer.
Thank you, Senator Shoebridge. I'm going to share the call. Senator Dunning.
Thank you, Chair. If I can go, please, to 84D, subsection 8, the Minister does not have a duty to consider whether to exercise the power to issue a permitted travel certificate in relation to a particular non-citizen, whether the Minister is requested to do so under subsection 2 or any other circumstance. Can you explain that to me, please? Like, what is there? If that was not included in the bill, would there be an obligation on the Minister to assess an application?
It was included in the bill to make it clear that because of the situation that the sort of circumstances or situation this could be dealing with, you may have thousands of visas affected at the same time. It's intended to ensure that as we work through them, we can work through permission. We're envisaging a situation where many people may seek at the same time a permission to certificate, and it's intended to ensure that we can work through those but not be under a duty where a court action, for example, is being taken to seek mandamus or the like to try and force a decision, noting that these are individuals who are offshore. They don't have that close connection to Australia in the form of a partner or a child here.
Yes, the exceptions and exclusions don't apply.
That's right. So it is intended to limit the use of, I guess, court applications to force permission certificates to be considered faster than, for example, our resourcing could cope with.
Yep. We'll come to resourcing in a moment. So just with that provision there, that obviating the Minister from having a duty to consider a request as it comes in, you sort of talk about that in the sense that it's about managing workflow because, 7,200 people might be caught up under this determination and you might get 7,000 applications. I doubt it, but you never know. So then that ability to not be required to consider, is it then open to the Minister to revisit on that when resources are freed up, or how does that work practically?
There's another practical consideration there. You did talk about the 7,200. This would be a process that is free of charge, that it's simply people making their claims and then providing whatever evidence to support them. We have seen circumstances in the past for similar processes where you get multiple applications despite a response already making it clear that they don't meet the exemption criteria. We then get every day we'll get another application, for example, and so that's another element here that we'd have to think about.
So the permit can only be applied if they meet the exemption criteria, is that right? Or?
No, there are no exemption criteria. It's simply that the Minister is satisfied that in all the circumstances it is appropriate for the determination not to apply to that non-citizen. If by criterion you mean the original visa criterion, that would be a key thing we would be looking at. So we would be thinking, if this person is saying, I actually have a very strong reason to come to Australia for a visit. Like
a student visa, for example.
Yeah, my course of study has 2 years to remain. I'm studying. I met a genuine student or a genuine temporary entrant. That's a kind of one where you would say, yes, it's appropriate for the determination not to apply to that person.
Okay, and so just back to the practicalities of this issue where a Minister doesn't have a duty to consider whether to exercise a power to issue these permits, a permitted travel certificate. Someone applies for one, having been caught up under a determination. If it is the case that the Minister does not consider whether to exercise the power, do they get a piece of correspondence back saying the Minister won't consider your request? How does that work?
So we would have a portal that would handle the correspondence.
Mm-hmm.
It would acknowledge incoming requests and provide information about the nature of our response. So it could be circumstances where we give an indication of when we would provide a further response, or it could be circumstances where
we won't.
We note that, for example, if it's a repetitive application that we've previously considered, then perhaps we might not be getting back to that person.
Okay. Just in terms of the information reported to Parliament on the permitted travel certificates and the number. What detail will be contained? Is it just the number that have been issued in the period, or will there be further detail available for scrutiny?
Just the number. We did consider what other information, but you can imagine it'll be deeply personal information because we're talking about individual, individual people who have put to us the reason they need to travel. So much like we publish numbers of visas granted, it's just a number.
Yes. So would it not be broken down, tourist, student, or whatever other category there might be?
On the face of the provision, that's not required.
But that wouldn't be too revealing if it were.
No, I think that would be consistent with the way we report on visas, where we do report total numbers and visa category.
Yeah, okay. Has the department tried to calculate or make any estimates in relation to the number of protection visa applications that might arise out of the conflict in the Middle East? And if so, which countries and how many? And if we haven't, why haven't we modelled as such?
Senator, that's a very challenging thing to model because it requires a huge number of assumptions. I guess the first one being, are they onshore or offshore applications? Mm-hmm. But I might let Mr Kiley speak to this.
Oh, yeah, so Andrew Kiley, First Assistant Secretary of Migration, Citizenship and Humanitarian Policy Division. As Ms Sharp said, it would require an awful lot of detail to go into nationalities who are currently onshore. We would have current application rates from a range of countries that would inform past behaviours, but to try and then extrapolate as to how that might inform future decisions that individuals would take would depend on a range of criteria, noting that these are very personal decisions that people would make to seek asylum onshore.
And if they are, just to add to that, if they are onshore, many people from countries affected by this crisis are here on skilled work visas, they're here on student visas. They may well have visa pathways in Australia where they don't need to apply for protection.
Sure.
They may well have been on a visa pathway anyway to remain in Australia, going through a kind of natural progression towards permanent residency. So it wouldn't be correct to assume that every person who's onshore now needs to apply for protection, which is why modelling this, it's not a simple one-to-one type of model.
Okay. Just back to resourcing then, and to the processing of these permitted travel certificates, for example. I mean, is there going to be further resourcing required by whoever's managing this section to deal with any potential increase in workload?
So, Senator, a lot would depend on the what the determination is and how many people are affected. Of course, if we put in place, if the government...
You must have, I mean, as in answer to Senator Shoebridge's question, what has been envisaged here is the risk related to Iran. So obviously there's a process to go through. So there must have been some thought put into... Certainly,
we have been considering, should the government make a decision to make a determination, what would be required to implement that. Mr Willard can probably speak a little more to it.
We'd be, if you take that as the example, that sort of quantum, we'd be looking at a consideration that's broadly, it's akin to a visitor visa consideration, that sort of level of processing in the broad. So in the context of our operation, we do 6 or 7 million visa decisions a year. This could result in a few thousand more considerations on top of decisions that have been made.
Sure.
It's not a huge impact. As Ms Sharp said, it obviously depends on what happens in the future and the nature of any determinations, and we'd make judgments then. But if we're talking about a figure of around 7,000, it's not a huge impact on our...
So therefore not requiring extra resources if we're looking at that number, theoretically.
No, I think the situation would be that we would be prioritising some of our existing resources to ensure that we were effectively managing the permission, stream. But that we would do that because what you would expect is we will see fewer applications from that area.
Of course.
So we will reprioritise to make sure we're giving enough resources to this to not have an enormous pile of unanswered requests.
Sure.
Thank you, Senator Duniam. Senator Shoebridge.
Thanks. So, to go back to the 7,200 Iranians who have been issued a temporary visa whom this could apply to, do I understand your proposition is you want to prevent them coming onshore here so that they can put an onshore visa asylum visa application in, but if they wanted protection, they should put an offshore humanitarian visa application in. Is that what's intended?
Yes, Senator.
The most recent data from Home Affairs website is from 23-24, and there were so few offshore humanitarian visas granted to people from Iran that it got that less than 5 response. There were less than 5. Do you have data, more current data for offshore humanitarian visas for people from Iran?
I've got on-hand numbers. I don't have recent grant data, but I've got on-hand numbers.
All right. Well, on-hand might be one small part of it, but obviously for people it's those that are granted, which is a far more meaningful number. We have, I think, very limited capacity for questions on notice. Is there any way you can find the numbers granted in 24-25?
I can see if there may be someone who is watching.
Please.
Senator, I don't have the precise answer to that question, but I have a figure of humanitarian visa holders who are Iranian nationals. There's 5,299.
Yes, but many of those would be people who have been onshore, who've arrived.
Yeah.
That would the offshore number, as I said, from 23-24 was so small. We got the less than 5. What is, if any of those 7,200 people have already been assessed as satisfying criteria for Australian temporary visa, if any of them put in an offshore humanitarian visa, they'd be at the back of the queue, is that right, in terms of the numbers?
It would depend on the level of priority that their application met. We've had discussions before, Senator, around the special humanitarian program priorities. There are also pathways through UNHCR, and ultimately it's a matter for government to determine how it wishes to exercise and use the places in the program in any given year.
How many people are in that queue? How long is the list of people offshore humanitarian visa applications? How many are on foot at the moment?
If you just over 200.
Yeah, about 250,000. I can get you.
So 250,000. And what's our annual intake?
It's 16,000 offshore places. There are currently, as at 30 November last year, Senator, there are 253,804 applications on hand.
So there's 253,000 applications in the system and 16,000 a year are being granted, and that's the system that we're saying to the 7,200, if any of them wanted to put an asylum application in, that's the system they should enter. Is that it?
That's right, Senator, but I think it's also important to note there are 4,000 places allocated to onshore applications.
Yeah, but you're ensuring they can't make those applications. That's the whole purpose of this bill, to shut the door, to say to Iranian women fleeing the regime, to say to Kurds, to say to political dissidents who may have a visa. The whole purpose is to prevent them making an onshore application. You're saying you cannot come here. We don't want you coming here because you might actually apply for asylum like the Iranian women football team did. You see what happened for the Iranian women football team. You don't want any more of that to happen.
Senator, we're conscious that if we had a very large number of onshore protection applicants, that would reduce the number of places available in the offshore intake, and that there is a very, as you've just highlighted, a very large demand from many very vulnerable people worldwide.
Or the government could say, there's a horrible illegal war happening in the Middle East. It's obviously going to cause refugees. As part of supporting a horrible illegal war in the Middle East, which produces refugees, we will, at least to those 7,200 who've already been assessed as safe to travel to Australia, we could at least give them an opportunity and increase the refugee intake to deal with these awful circumstances. That's another option. That would be another option, wouldn't it?
Senator, that's a question you'd need to put to a minister, I think.
But to be clear, we had the government today trumpeting the fact that they'd granted 5 visas to incredibly brave Iranian women from the football team, and of course, if they seek asylum, they should. But yet, in the exact same day, the government is shutting the door to 7,200 other Iranians who currently have temporary visas to make sure that that cannot happen again. Does anyone in the government look at doing the 2 things in the same 24 hours and say, this is incoherent, inconsistent policy? Is anyone looking at these 2 things happening at the same time?
Senator, the legislation does not apply to people who are onshore, and we are actively working with Iranian visa holders who might have a temporary visa onshore to ensure that they remain lawfully in Australia.
But there are hundreds, if not close to 2,000 Iranians onshore who are caught up in fast track or have been caught in that mess because they were brought here under Medivac, who have asylum claims out. Do we know how many there are onshore? Iranians onshore who have live asylum claims?
I'll check if I have that.
Mr. Kelly, did you get any of those other numbers?
I've texted, someone's chasing the numbers now.
Okay, thank you. Do we know how many are onshore?
Senator, we didn't come to this hearing on the bill with data on the fast track cohort. I don't think we were focusing in on
There's
the
also
most likely to be affected.
The
by
Medivac
this.
cohort, I forget the name of that cohort because it's
Transitory people, I think is the term.
Transitory people.
So, Senator, I do have the numbers of Iranian protection visa applicants as at, again, 30 November, so apologies, the data's a touch out of date. There were 1,108 on hand protection claims from Iranian nationals.
And are they both fast track and transitory?
No, this is the protection visa caseload, so this is not fast track or transitory, this is the protection visa caseload.
Okay, and they're onshore? Sure. And that, in addition to that, is the fast track and the transitory?
Yes.
All right, you don't have those numbers?
I'll check.
Thanks, Mr. Kelly. And I know you've been brought here on short notice as well. And the reason I'm asking, Ms Sharp, is because part of what the argument here is there's a resourcing stress. And you're telling us that some of the resourcing stress is dealing with claims that are coming as a result of this same conflict onshore. So to get an understanding of what the resourcing stress is, we need to know the claims of those who are onshore.
Senator, I think what we're saying is we don't have the resourcing to assess the 7,200 and make individualised cancellation decisions based on the people's facts having changed such that they wouldn't be granted the visa now. We're not. I'm not sure that questions about the number of transitory or fast track people in Australia is directly relevant to this bill, but if we have the data, no concerns in providing.
Just noting, I'm just pulling a couple of numbers together, but again, at 30 November, the number of Iranians in the UMA legacy cohort, as we've sort of discussed in committee hearings, is approximately 1,130.
1,130. And sorry, Ms Kelly, that they are they are, how do you describe that cohort?
It's essentially individuals who are either undergoing a temporary protection visa or SHEV application or have been refused a temporary protection visa.
And that would cover the fast track and transitory cohort broadly?
Probably not the transitory cohort, no, but the fast track cohort, yes.
Fast track cohort, 1,100 there. Okay, thank you. Sorry, Jeff.
Thank you, Senator Shuey. Senator Dunnigan.
Thanks. With not much time left, I was going to ask, so just in terms of geographical application of determination, would it be envisaged that it would apply to anyone from a nation or a region? How does that work?
There's sort of two levels on which to think about that. The first is the law. The law itself says it applies to classes of person.
Classes of non-citizens.
Classes of non-citizens, I should say.
Yes.
So it's not specifically on the face of the legislation limited to definition by nationality, but in practice, in our systems, I can identify classes of non-citizens by the origin of their travel document and by the class of visa they hold.
And so then you'd run, so a determination, or advice being put together for a determination to be made would target a cohort of non-citizens offshore, and then, despite it not being specifically referenced in the legislation, it would be isolated. How, for example, with the Iranian cohort, would it be anyone on a travel document originating from Iran? Is that how it would be done?
Who holds a visa of the following types?
Yes.
Or it could have a subclass of the visa or even a stream. Some of our visas have streams within the subclass, it being the Migration Act and particularly complex. But it needs to be an identifiable group that is sufficiently clear for it to go into a legal instrument. So it will. Yeah, so what we expect is it will be definition by the travel document plus the visa type.
Okay. That being the case, definition by the travel document and its place of origin, you couldn't then go down to region, for example, if it's a larger country affected in part by an event or circumstance. Could you do it that way?
I think there's, again, two answers to that. One is the policy reason for doing this is that we are concerned that the person won't have the ability, won't leave Australia. If they have a travel document to go back to a country where large parts of the country are unaffected by the event, then there's not a strong policy reason for doing this. And secondly, I don't think our systems could, in a sufficiently robust way, classify and then have our systems and our records to be able to match to a sub-region in that way.
No, and I think I'd add once someone holds a visa offshore, we know if they're either offshore or onshore, but we don't know where they might have moved to within their country or moved to another country. Those sort of pieces of information we wouldn't have. So when we define that cohort using travel documents, would allow us to do it within the systems we have.
Sure. And just two other questions in relation to under 84C, where the determination doesn't apply to certain cohorts or certain individuals. Are these sort of a standard collection of categories that apply across other elements of the Migration Act when seeking to exclude certain groups from the application of a law, or have they been designed especially in relation to what we're dealing with here?
They've been designed for this purpose.
Okay. And the 7,200 from Iran, for example, is that a number net of anyone who might fall into this category?
No, that's
the total holders
total
of
number of visa holders. It
Yep.
doesn't exclude this category.
They would have to make a claim.
No, they would be
Automatically?
They will be automatically not in scope of a determination. It's just our data.
As it stands
As
today,
it stands.
sure.
I guess I would just make the observation, particularly relating to those captured by 84C1, which is that the person holds a temporary protection visa, for example. They're unlikely to be also holding a visitor visa.
No.
Yes. Do you know what I mean? Like, practically, I don't think they're going to overlap much, but the group identified in subparagraph 4 by contrast,
yes,
there will be quite some overlap because
spouses and...
Although, again, most spouses will have a partner visa or a different... Right. But there would be cases, I think, of some temporary visa holders caught by 4, in which case the determination will not apply to them and they can continue to travel on their current visitor visa or what have you.
And just so I'm absolutely clear, the case is for anyone under 84C, by virtue of meeting one of these criterion, for want of a better expression, they don't need to then apply for a travel permit, the permitted travel.
That's right.
Document.
They do not need to.
They are automatically exempt from the determination.
That's right.
Okay. All right, thank you, Chair.
Thank you, Senator Dunningham. Senator Shoebridge.
Thanks, Chair. I'm sorry, Mr. Kelly. I know it's unreasonable, but I'm going to ask again if you've got any fresh numbers.
They're working on it, hopefully in the next 7 minutes, but they are absolutely working on it.
Could I go to the how it is that a permitted travel certificate, how will it be applied for and how will it be assessed?
So in terms of how it would be applied for, it's through a portal mechanism. So an individual would fill out an online form, attach any statements or claims and evidence that might be relevant, and then they'd lodge the application through that mechanism.
And did I understand from your answers to Senator Dunningham that the intention is that those permitted travel certificates won't be processed with any degree of urgency? They'll be... What is the rationale? What is the intent in terms of processing?
No, the intent would be to like any caseload, to respond to the needs of the caseload and make decisions about prioritising different cohorts depending on what sort of claims are put forward.
So is there any thinking about how they might be prioritised?
In the broad, we apply a test around compassionate and compelling circumstances that affect the interests of Australians. So that's the test in the broad. So that's that sort of situation where there might be a particularly compelling or urgent situation where an individual needs to travel, and that's how we prioritise those sort of decisions.
So one of the visa classes that would be caught up in this, if a determination was made, would be a prospective spouse. It's prospective spouse visa that would be caught up in this.
So that would only be if in the making of the determination and in the definition of the class of persons that prospective spouse was included as one of the
If there was a
subclasses.
determination, for example, to apply to people on an Iranian travel document, and that was the class, they wouldn't be excluded because they wouldn't be a spouse, they wouldn't be, unless they were also by chance fit one of the other criteria in 84C, a prospective spouse visa would be caught if a determination was made for Iranian people travelling on an Iranian document.
So when the way in which the class would be described is that travel document, as Ms Sharp said, and then it would be the visa classes and subclasses. So within temporary visas, as you know, there's lots of subclasses.
If a determination was made about Iranian travel documents, and that was the starting point, unless they were expressly excluded, they would be caught up.
Yes, I mean, if they were listed, they would be caught up.
Yeah. I just want to check I'm reading the legislation right. That's the effect of it.
If we specify, yes, it could be.
Well, if you specify Iranian travel documents, unless you expressly exclude them, then they will be caught up because they're not excluded under any of the exclusions in 84C.
So in the definition of the class of persons, it would include the visa types that are impacted. So
yes, but unless they were picked, once you start with the Iranian travel document, which I assume is your principal, you'd start with the travel document and then say people with that travel document, and then you'd start enumerating, potentially you could enumerate the visa. You wouldn't have to. You could just identify travel document, and then you've got the statutory exclusions. But unless you went through the process of excluding that in one way or another, having started with the Iranian travel document, they'd be caught up. That's how the legislation works.
Look, either way, regardless of which way this instrument is drafted, a choice will be made about which visas to include, and it may well be drafted the way you describe, or it could be drafted the way we describe, which is a list of visas that are included.
Have you done any assessment to work out how long it would take to assess individual applications for permitted travel certificates? Because potentially 7,200 people could apply for a permitted travel certificate, and then you're in the exact same situation you started with. Have you done any assessment of that?
We don't expect that all 7,200 will apply for a certificate, and in terms of how long, it will depend. As Mr Willard said, we will apply prioritisation based on the information in there about how urgent the need is to look at the particular one in front of us.
And is one of the reasons you're thinking, well, 7,200 people won't apply for a certificate is because they're currently in a war zone, being bombed by Israel, being bombed by the United States, being attacked by their own regime, and have poor internet connection? Is that one of the reasons why you assume that they won't apply for a certificate? Because it's bloody hard when you're being attacked by so many people?
I actually had in mind a scenario where, and I do not want to downplay, the war is incredibly serious and devastating in the way you described, but the scenario I had in mind when I said that was in fact that somebody had applied for a travel visa, for example, 12 months ago and had with multiple entry permits on it and had already travelled to Australia. So they've got a valid visa, but the trip they applied for, the visa might have a certain duration and they could use it again, was the scenario I had in my mind when I said I don't expect all 7,200 to apply for a permission.
Which I've got to say, if that's the case, then they wouldn't have had the potential caseload impact. That they wouldn't, if that's the assumption that they wouldn't have come here anyhow.
The challenge is...
Then how does that justify this bill?
The challenge is that without going case by case through the 7,200, we can't differentiate, which is why we need the power to look at the whole class and then be able to do this work through the permission process to unpick who has an urgent need to travel so we can focus on their requests.
Thank you, Senator Shoebridge. We are at a hard marker of 6:30. That concludes today's proceedings. I thank all the witnesses from...
Sorry, Chair. Did we get the numbers?
I had dots. I'm expecting it to come through very soon. We can certainly email it to the Secretariat as soon as we can.
I thank witnesses from the Department of Home Affairs for your evidence at the committee today, particularly given the workload that you've had this week, long days and late nights. And thanks also to Broadcasting and the Secretariat for the very swift setup of this evening's proceedings. Greatly appreciated. Can I please ask that a member of the committee move that answers to questions taken on notice should be returned by 10 a.m. tomorrow? Thank you, Senator Blythe. I declare this hearing adjourned.